it's my proud privilege to introduce to you Advocate Mansi Bajaj, who possesses rich experience of more than a decade in this field. Her expertise lies in handling medical legal cases, and she has been assisting and consulting reputed institutions such as Gandhi Cancer Institute, Sardarnath Hospital, Venetia Memorize Hospitals, NGS hospitals in their medical dilemmas. She is currently running her independent practice by being every associates. And now, without taking much of your time, I request Mansi to start with her presentation.
Thank you so much, Sippy. I thank Holistic Healthcare Solutions and Dr. Sippy Malhotra for giving me this opportunity to do this webinar. And I would also like to thank Mr. Rajiv Bansal, who has always been my mentor, my guide. He has pushed me into this. So thank you so much, sir. I know you're always there. I would also like to thank my husband, Mr. Amit Bajaj, for the technical support, because I'm not that tech savvy. So thanks, Amit, for it. Am I audible, Sippy? Hello, Sippy?
Yes, go ahead.
I'm audible. Okay. So let's start the webinar.
Yes, you're audible.
Okay. So let's start the webinar. The topic is elements of medical negligence and how do the doctors safeguard against litigation. Nowadays, we have seen there is an increase in medical negligence cases. So I'll start the webinar with a very famous quote we have all heard: "To err is human," and every human can make mistakes. A doctor, at the end of the day, are also human beings, so they also make mistakes. So you'll have to just give me a moment. I'm sharing my PowerPoint presentation with you all. So just give me a moment. I'll just. Sippy, is the PowerPoint presentation audible, visible? Sippy? Can we now see the presentation?
I think it's going to start now, but not yet. Now we can see.
Yeah, you can see it?
Yeah, we can see.
Okay, thank you so much. Thanks. Okay, so as we start, as I just said, to err is human, and at the end of the day, all doctors are human beings. So they are bound to make mistakes, but there is a very thin difference between an error of judgment, an error, and medical negligence. So we should first know what is error of judgment, and then probably we can go back to what is negligence. So the difference between error of judgment and negligence. Error of judgment happens in such cases it has been recognized that it does not amount to a breach of duty. Merely because a doctor has taken a decision to go with one kind of a treatment, that doesn't mean he has breached his duty. He has seen the pros and cons of the treatment module that he has planned, and then he takes a decision. So if there is no breach of duty, it cannot be proved that it is medical negligence. And there are catenary of judgments on this. I'll share the list of some landmark judgments with you, which talks about that there is a huge difference between error of judgment and negligence. So I'm just quoting one part of the recent Junjunwala case. It says, A medical practitioner cannot be held liable simply because things went wrong from mischance or misadventure or through an error of judgment in choosing one reasonable course of treatment in preference to another. That is what I just said. Just because a doctor thinks that this mode of treatment is better than the other one, that does not mean it is negligence. So now
Excuse me, ma'am. Have you not started the slide?
I have. You can't see it?
We are not able to see. We are just seeing your screen.
Just give me a moment there. You can see it now?
Now it's up. It's
Okay.
visible.
So I've just finished this error of judgment slide.
Sure.
Okay. Thank you so much for this help. Thank you. So moving forward, now we can discuss what negligence is. So going by the definition of medical negligence, it can be defined as the omission to do something which a reasonable man, guided upon those considerations which ordinarily regulate the conduct of human affairs, would do, or doing something which a prudent and reasonable man would not do. And please mind it that in courts, it is always seen that the highest degree of reasonable care is not expected of any doctor. It is only that a reasonable care has to be there. He has not breached that duty. He has taken care of all the standards of care. And then probably this medical negligence can be avoided. So moving to the next slide. Now there are four very vital elements of negligence. So if these things are not there in a case, probably negligence cannot be proved. The first one is that a duty of care was owed by the physician to the patient. Obviously, when the patient comes to the physician and the physician starts treating that patient, there is a duty of care that the doctor owes towards the patient. So that duty of care is there. Second is that the physician violated the applicable standard of care. So there are some standard of care. For example, there are some standard guidelines which are followed by all the doctors. I can talk about cancer. There are NCCN guidelines which the doctors are supposed to follow. So, um, okay, so that a physician violate that principal standard. So, as the case in cancer, there are other specialities, gynae, cardiology. So they follow their own standards. So once it is there that these standard of care has not been violated, you cannot prove negligence. Moving forward, that the patient suffered a compensable injury. So just because there was a breach of care and the standard has not been followed, but sometimes it happens that the patient did not suffer any injury. So in case there is no injury, obviously the negligence cannot be proved. Next is that such injury was caused, in fact, and proximately caused by the substandard conduct of the physician. So this is where error of judgment comes into place. You can say that yes, these were not followed, but there was an injury, but this injury was not, it did not happen because of substandard conduct of the physician. Probably the physician took all care, but somehow it happened. Okay. So now moving forward, I think it's a very important topic which says that many a times I have been asked these by my doctor clients that which are the courts in which the cases can be filed by the patient. So basically speaking, there are four courts. One is under Consumer Protection Act. So the case is filed under Consumer Protection Act in consumer courts. Then is civil law. The patient can always file a writ. Then is the constitutional remedy, and the last and the final is criminal law. So if the patient has died, the patient can always go, the attendants can always go to the police and file an FIR against the doctor in under section 304A of IPC. I'll just have to hold for a moment. I'll just have to hold for a moment, please. It cannot be done in this time. I beg your pardon for those who are on Facebook, they won't be able to see the slides, but those on Zoom can see the slides. So I'll have to bear with this. I'm not that tech savvy. So, anyways, moving forward, I think I'm audible to all.
Yes, ma'am, you're audible. The screen is also audible.
Okay, thank you so much. Thanks. So moving forward, so whenever a case is filed under Consumer Protection Act, so there are some hierarchy of courts that has been uh, decided by Consumer Protection Act. So a complainant can always go to a district forum, which is called District Consumers Disputes Redressal Commission. The pecuniary jurisdiction in now this pecuniary jurisdiction in any case has changed. So the pecuniary jurisdiction is not exceeding rupees 20 lakhs. So if a patient files a complaint asking for a compensation of, you say, 18 lakhs or 19 lakhs, that person will directly go to District Consumer Disputes Redressal Commission. I'm sorry, it should be forum. It should not be commission. District Consumer Dispute Redressal Forum. Moving forward, then State Consumer Dispute Redressal Commission, which pertains, the pecuniary jurisdiction is rupees 20 lakhs, not exceeding rupees 1 crore. So sometimes the patient feels that 20 lakhs is less an amount to be paid for. So then they go to State Commission asking for more than 20 lakhs but not exceeding 1 crore. The next is National Consumer Disputes Redressal Commission, which is also called National Commission. So the patient still feels that no, even 1 crore is not enough. I should ask for more. So then he can directly go to National Commission filing a case. And all these, starting from State Commission, National Commission, Supreme Court of India, they have the appellate power. So in case a patient is not, or the aggrieved party, I can say doctors also, if the aggrieved party is not satisfied with the order of the district forum, they can always appeal in State Commission. The orders of the State Commission can be appealed in National Commission, and the orders of the National Commission can be appealed in Supreme Court of India. So nowadays, in fact, this was always there, but now I've seen an increase in these kind of cases also when the complaints are filed in the State Medical Council. So whatever forum the patient decides, it's his will. He can first go to Consumer Court, then file a case at State Medical Council and go to police. So, and it can be done simultaneously also. So when a complaint is filed at State Commission, it is under the Indian Medical Council Professional Conduct Ethics Regulations 2002, Section 8.2, which states that a complaint can be filed against the doctor at State Medical Council. The State Medical Council then holds an inquiry and an order is pronounced. So sometimes I've seen in State Medical Councils, the doctors are called during the inquiry, sometimes not. Sometimes if they feel that it is not a very grave negligence or there is no negligence, then they do not call the doctors to State Medical Councils. The order of the State Medical Council can always be appealed in Medical Council of India according to the same regulations, Section 8.8, which says that the aggrieved party can file an appeal at Medical Council of India within a period of 60 days from the date of receipt of the order of the State Medical Council. So the day the aggrieved party receives the order, 60 days start from there, and within 16 days you can file the appeal at Medical Council of India. In Medical Council of India, I have seen generally the ethics committee call the doctor, they hear them, a written statement is filed, and then the final order is given. So as I was talking about, these are some of the landmark judgments of the Supreme Court of India. So I feel every doctor should go through these judgments, because medical negligence, it's a law which has evolved in time through these judgments. These judgments are very important if you want to understand what medical negligence is. So one such case is Indian Medical Association versus VP Shanta. This was the case after which the medical profession came under the purview of Consumer Protection Act. Before this judgment, medical profession was not under the purview of Consumer Protection Act. This is a very beautiful judgment which will describe what is contract for service, what is contract of service, and why medical professionals should be under the Consumer Protection Act. Next is Permanent Katara versus Union of India and another. Then is Spring Meadows versus Aluwalia. Then comes Samira Kohli versus Dr. Prabha Manchanda. Now this is also a very good judgment if the doctors want to know what should be a perfect consent be like. So the Samira Kohli judgment will tell you why you need to take a consent, under what circumstances you can take it, and under what circumstances it is not required. For example, if it is an emergency situation, obviously the I mean, rather than going into the consent and all that stuff, the more important thing is to get started with the treatment. But yes, in this case also consent is important. Then is Jacob Matthew versus Government of Punjab, Kusum Sharma versus Badra Hospital, and the last but not the least, Dr. S.K. Junjunwala versus Dhanvanti Kumar. This is the latest judgment. This is October 2018. This also talks about what is medical negligence and why doctors should not be always blamed for whatever has happened. Because I've seen in many cases that patients are under this impression that because something has gone wrong with our patient and you have to blame someone, let it be the doctor, which is not the case. I mean, in my career, I've seen that no doctor will ever want that his or her patient should suffer or should lose his or her life because of any negligence. So it is never intentionally done. See, we should all understand that at the end of the day, we're all humans. And every human body reacts in a different manner. Probably that same medicine to me will react in a different way. To you, it will react in a different way. So now we can discuss, there are some safeguards that the doctors must take. So whenever I take a class for doctors, I always tell them the same thing, which I'm again repeating, that documentation is the only thing that can save you in court of law. Whatever has happened in OT or in wards or in OPDs, nobody knows. Whatever verbal communication happens, nobody knows. So it is only your documentation which has to be very, very proper if your case is there in front of the judge. So judges go through each and every paper. They need a medical typed copy, the typed copy of all these documents, because the handwriting of doctors obviously cannot be ascertained by them. So they need a medical written typed copy, which they go through very, very calmly, and they take time reading it. So this is what I think is the main focus should be on the documentation. The medical record is a very crucial element in preventing and minimizing the potential adverse consequences of medical litigation. It serves as the basis of the defense. There is no other defense available with the doctor. And please mind that medical records which are poorly maintained, they are incomplete, inaccurate, illegible, or altered, will cause the judge to find liability against a hospital and or healthcare provider. But it does not mean that you cannot make changes to the medical records when the treatment is going on. You can always cut and write and then sign in front of it, so that everybody knows that yes, this is the mistake that was done and which was corrected at that time. But I will not suggest to alter your medical documents after the treatment is over. So please don't do it. Or you see that there is a medical negligence case coming up, you've got a legal notice, and then you start altering your medical records, please don't do it. So how a proper documentation should be. Each and every page of the patient record should be clearly labeled with the patient's complete name and MRD number. MRD is Medical Records Department. So there are different terminologies in all hospitals, in all clinics. So I have just written it as MRD. So please make sure that every page is paginated, because if it is not paginated, the judges feel that there can be an alteration. So you can always put one page if you see that there's a medical negligence case. So please do not do it. All entries in the medical record should be dated and be signed by the person making the entries. This is very important, because I've seen in many documents that sometimes it is not dated. Sometimes the error of AM PM is done. Sometimes it is not signed. In fact, if I may say, nowadays I think doctors are also putting their stamp, the DMC number so and so, which can also be done. It's a good way. But I'll just say that please make sure that your medical documents are dated, timed, and signed. Please make sure that these things are there. So, as I just said, patient records should never be altered. Please don't erase, obliterate, or attempt to edit notes. And all corrections, late entries, entries made out of time sequence and addenda should be clearly marked. So as I said, you can always make changes, but please make sure that it is signed, clearly marked as such in the record, and should be dated and timed on the day they are written and signed. Draw a single line through any erroneous chart entry and write error with the date and time as well as your initials. So wherever there is an error, please put your initials so that everybody is aware that is not done with a malified intent. Now, these are some of the preventive steps, again, that the doctors and hospitals as such should take to avoid litigation. There are 4 levels of it: primary prevention, secondary prevention, tertiary prevention, and quaternary prevention. So these are 4 kind of preventions that should be taken. Primary prevention is, so when the patient is entering into your hospital, he doesn't come directly to the doctor. He meets the receptionist, he meets the junior staff, the cleaners, the other staff. So all in all, the behavior of the entire staff should be continuously monitored, especially in stressful circumstances, especially in these kind of circumstances when we are facing COVID-19. I think it's a very difficult situation for the doctors and the hospitals. I know how they are managing things. So I mean, mostly in these kind of circumstances, this should be done, but otherwise also. Then the commercial attitude should be discouraged. Obviously, I mean, medical law is like that. It says that there should be no commercial angle, uh, which is there. Then I think the communication of the doctors are very, very important. So till the time, I've seen many a times that the doctor is very nice. He is thorough with his subject. He has dealt with thousands of patients, but is not communicative. And till the time you do not communicate with your patient, they will not understand what kind of prognosis you have made, what kind of diagnosis you have made. So you have to go to the level of the patient to make him understand what is he suffering from and what is the course of treatment you think should be best and why. So taking consent is a very important part of any doctor's life. But consent should not be merely a formality. You have to sit with the patient to make him understand that these are the pros and cons of the treatment I'm gonna take. You have to know all the medical history properly. You have to know what allergies he or she is facing from. So till the time this is done, probably any doctor uh, can obviously not enter into medical negligence cases. I've seen in many cases that medical sometimes it is not the negligence that has happened, but somehow the patients feel that the doctor did not talk to me in a right manner. He was egoistic. So I know it's very difficult for doctors to handle so large OPTs, but you have to do it at the end of the day. So secondary prevention is Again, proper documentation. I think we've talked about documentation, so I will not get into it again. Then preservation and supply of records. This is very important. Sometimes I've seen in my cases that the doctors say that the patient came in OPD and I wrote a prescription and wrote the treatment and gave the treatment notes back to him, which is not right. You have to have the doctors, the hospitals have to retain a copy of the record of the treatment that you're doing with you're administering to the patient. It is good for you also because at these kind of circumstances when you're there in court, how you want to prove to the judge that this is what I have done if you do not preserve the records. Second is supply of records. According to Indian Medical Council Act, within 72 hours the patient give within 72 hours you have to provide the patient the medical records, and it has to be signed by the medical superintendent and whosoever is the managing authority of the hospital or the clinic. So please make sure that, so you cannot refuse a patient the medical records within 72 hours of his making the application to you. You have to supply the medical records to the patient. Then yes, it has to be a legally valid consent. See, consent is a very important part of medical negligence, but consent in as such is so large. I don't want to get into the consent thing because then we'll go on and on and on. But yes, it is a very important part of consent, and the judges, please do not think that the judges do not look at consent forms. They look at it very, very nicely. So please make sure that you have a valid consent form before you are starting the treatment. Nowadays, there are informed consent, plus there are, consent is required for every treatment which you are administering, even for blood transfusion. So please make sure that the consents, valid consents are there. Then comes your tertiary and quaternary prevention, which is professional indemnity. Now, nowadays, in fact, it is mandatory that all doctors should have the professional indemnity insurance. And it is so good to see that these insurance companies, they have now come up with the plans in which they are covering the litigation charges also. So they have a panel of lawyers who will give you the litigation support in case there is any litigation or any legal notice that you require. So this is a very good thing that the insurance companies are there. There are many good insurance companies which are working on this module, and I will like all the doctors to please have these kind of insurance companies which has these litigation cover. Now, defending litigation by forming medical defense societies and strong peer group. This is very important because somehow I have seen that it's lack of unity amongst the medical fraternity. It is thought that it is not required, but I feel that if you have to bring a change in these kind of cases and the increasing medical negligence cases, I think you must have a very, very strong peer group. And they are very helpful. I've seen in many cases that the peer groups are very, very helpful when the cases are filed against you. They are ready to stand with you. They are ready to give you the literature, all kind of support which is possible. Okay, so coming back to now, there is an amendment which has just happened in the Epidemic Diseases Act through an ordinance dated 22/4/2020. This was required because of the COVID situation which we are all facing. I have just penned down very vital sections which are amended because I don't think you will be needing many more amendments which are there. So section 1A1 has been amended, has been inserted in this act, which has defined act of violence. So act of violence includes harassment, impacting the living or working conditions, and intimidation. So any kind of violence against the doctor has now uh, a punishable offense. Section 3(2) and 3 has been inserted, which says punishment from 3 months to 7 years and fine from rupees 50,000 to 5 lakhs. This is there. Now it has now become an offense. And section 3A, offense is cognizable and non-bailable. So in case you have to get a bail, you'll have to go to the court for getting the bail. Next is section 3AA2, which says investigation by a police officer not below the rank of inspector. So whenever there's an FIR which has been filed, so an IO is always allocated to the case. So in these kind of cases, the investigation should be done by a police officer not below the rank of inspector. So it shows that now we've all realized that probably these kind of offenses should not happen, and an immunity to doctors are very, very necessary. Then section 3A3, investigations to be completed within 30 days of filing of FIR, and section 3A4, trial to be conducted expeditiously on a day-to-day basis without any unnecessary adjournment, to be concluded within 18 months. So again, probably now we have realized that an immunity is to be given to the doctors, but I'll just say that these amendments have been brought through ordinance, and an ordinance is valid only for 6 months. So this is not an this it's not an act which can be used after epidemic act has been revoked. And that is how here I think the peer group will come into picture. I think all the doctors should take this up to the government so that these acts are amended and you are given an immunity under all these acts. So I'll just conclude by saying that just because something has gone wrong with the patient, please don't uh, start blaming the doctor. He must have done something wrong, which has happened. Because doctors are very honorable people. And I'll just tell you one thing, and that was very disheartening for me, for a lawyer. There was a case of a very famous cancer surgeon. He had done thousands of surgeries. So he told me before entering the courtroom, Mansi, I am never afraid to enter into an operation theater, but today I'm so afraid to enter into the courtroom. So this happens with every doctor. So many people, so many doctors have come to me. They will say, I've done everything for this patient, and look, now this patient has filed a medical negligence case against me. I don't want to practice. Please, I will just say that do not get into that mindset. I mean, this for the doctors. Please don't get into that mindset. You have put in a lot of efforts in all these years to reach where you are, and one medical negligence case cannot just break your courage. And we, on behalf of the whole legal fraternity, I can just say we're standing with you in your support. Whenever you need us, we are there. So thank you so much for listening this. So
You want the first thing.
hello.